Hello, friends, and my dear viewers. Welcome you all on my YouTube channel. This is Dr. Gyanendra Fuljalke. Today we will discuss rights of surety. In our previous lectures, we have discussed that what is the contract of guarantee, and now in this lecture we will discuss rights of sureties. So, in our last lecture, we have discussed that according to 126 section, it defines the contract of guarantee. Contract of guarantee is nothing but it is a mutual legal relationship between the three parties, that is a creditor, principal, and surety. And if these three parties come together, it forms a contract of guarantee. So, surety is very important factor or important party in the contract of guarantee. Hence, we must understand what are the different rights which are available to every surety. So, first right we will discuss, that is right of subrogation, section 140. This means that the surety steps into the shoes of the creditor. Whatever rights the creditor had are now available to surety after paying the debt. Okay, so right of subrogation is very important right of every surety. For example, the principal debtor become defaulter and he could not pay the money to creditor. Then, if surety paid the money on behalf of the principal debtor, then the surety steps into the shoes of the creditor and he will become creditor and he can exercise all the rights which are available to creditor against the principal debtor. In Kadamba Sugar Industries Private Limited versus Devaru Ganapati, AIR 1993, Supreme Court of India held that surety is entitled to the benefits of the securities even if he is not aware of their existence. Means it means that the whatever the securities are provided by the principal debtor to the creditor, and if surety paid the amount or paid all sums, then he is entitled to all such securities. Next, second right of every surety is very important right, is the right to indemnify, section 145. Surety is entitled to recover from principal debtor whatever sum he has rightfully paid under a contract of guarantee, but no sums which he has paid wrongfully. It means that indemnify means the principal debtor have to indemnify the surety, because surety had paid the amount on behalf of the principal debtor, and now it is the right of every surety that they can claim it as a matter of right from the principal debtor. But the payments which are made by the surety should be legal payments. If wrong payments are made, wrongfully payment is done, such payment is not recoverable under this right. In Chakramma Punamma versus AS Tathayamma, AIR 1983, the Supreme Court of India held that the surety have to show how much amount was realized by the selling of vehicle, which he could not show. Thus, it was held that payment made by the surety was not proper. So, it is the duty of surety he have to prove that how he had paid the amount, and if he could not show the expenditure, then he cannot make it as a right of right. Next, right to securities, section 141 of Indian Contract Act 1872 defines a surety is entitled to the benefits of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into whether the surety knows about the existence of such security or not. Means right to securities. So every surety is entitled to securities which are provided by principal debtor to creditor, and he can claim it as a matter of right. Govardhan Das versus Bank of Bengal 1891. It is important to note that the right to securities arises only after the creditor is paid in full. Whenever there is a full payment by the surety to creditor, then only the surety can ask for the right to securities. Fourth right of every surety is that effect of realizing a surety, releasing a surety. Where there are co-sureties, a release by the creditor of one of them does not discharge the other, neither does it free the surety so released from his responsibility to other co-sureties. Sometimes co-sureties are there, and creditor if release one of the surety, it doesn't mean that he has released all the sureties. Section 138 imposes responsibility on rest of the creditors also, so rest of the sureties. And the this is very important right of every surety, that if a particular surety is released, then he also can claim the release from same. Sri Chand versus Jagdish Prasad, AIR 1996. A creditor can release a co-surety at his will, at that time. It means that it is a discretion of the creditor. He may release any surety at any time, but other sureties will be responsible up to their liability only. Fifth right of every surety is the right to contribution. Section 146. Where two or more persons are co-sureties. This question is arise when there are co-sureties. And for example, if there are four sureties in a contract of guarantee, and for example there is a surety which is furnished of 1 lakh rupees each, means 4 lakhs rupees transaction is there, and every surety is responsible for 1 lakh rupee. So every surety is responsible up to 1 lakh rupee plus the interest of that amount only, and it is a right to contribution, means every four sureties must contribute, and they shall make the payment to creditor. So thank you friends for your patience listening. If you like this video, please share it with your friends. Thank you.